The documents they seized, easily half of them involved my representation of the President of the United States as a lawyer. They read all of it, including secret communications between lawyer and client. And then they decided if they were privileged. Now, how do they know if they're privileged? They didn't ask me. They didn't ask President Trump. I mean, if they did this to an ordinary citizen, they'd be fired, disbarred, and thrown in jail.
I mean, that's insane. That's President Trump's personal attorney and friend of the show, Rudy Giuliani. He told Greg Kelly Reports last night that the FBI raid on his office and residence violated attorney-client privilege. I tend to agree with him, but let's ask Alan Dershowitz. He's a great legal mind, and he has a great new podcast, The Dersh Show. He's also the author of The Case Against the New Censorship, Protecting Free Speech from Big Tech, Progressives, and Universities. Good morning, Professor Dershowitz. I mean, I am shocked by this. The officers on site decide whether it's privileged or not?
Or no. What the government does is they seize it all, and then they give it to some prosecutors. They call them the tank team. Those prosecutors read all the privileged information, and they decide what to turn over to the prosecution team. I want every one of your viewers to imagine if you went to a priest and told him the most secret things in your life, a psychiatrist, a doctor, a lawyer, and then they searched the priest and they read what you told the priest. They read what you told your cardiologist, your psychiatrist, and then they said, well, all right, this is privileged, so we won't use it in a trial, but the government has already read it. That's illegal. The Fourth Amendment doesn't protect you only against criminal prosecution. It protects your privacy. And so in situations like this, they should always use a subpoena, not a search warrant. They subpoena your cell phone. Your lawyer then goes to court and says, no, my cell phone has information about conversations, communications I had with clients. And the judge says, no, you can't see that. I can't see that. Nobody can see that. That's the way to do it. But to conduct a search warrant is to imply that Rudy Giuliani and the other lawyers who were subject to the search warrant would destroy evidence. Now, Giuliani knew that they were after the cell phones and the computers for months and months and months, and he didn't destroy anything. So what's the basis for the search warrant rather than the subpoena? The Fourth Amendment demands a subpoena in these situations, not a search warrant. And what they did in this case was unconstitutional.
Right, but the damage, like you said, is already done. They've already read it. So now, we all know that how the FBI and some of these other federal institutions work, where, you know, it may leak here and there, and they may get this, they may get that. I mean, like, the damage is kind of done. So what's the recourse, and, you know, what happens?
Well, there's various types of damage. Just reading it alone. If somebody reads what I tell my rabbi or what I tell my cardiologist, that's damage enough. Then it's a taint team. What is a taint team? They're prosecutors who work next to the other prosecutors. They have lunch together. They promote each other. Inevitably, it leaks inside the office, and then it leaks outside the office. We know, although the U.S. Attorney for the Southern District of New York has been pretty good at not leaking things, inevitably things leak, particularly if they involve former President Trump or his lawyers. So the remedy is his lawyers. I've been consulting with Rudy Giuliani's lawyers. They asked me for my advice on this, and pro bono, I've given them general advice, as I would to a Democrat who called me and asked me about constitutional violations. They ought to move to, A, get the material back and have the government subjected to subpoena analysis. B, they ought to reject the idea of a taint team and require that if anybody goes over this, it ought to be a judge, a magistrate, or at least a master outside of the prosecutor's office appointed by the court. That's what happened in the previous cases. But the idea of having one group of prosecutors tell the other group of prosecutors whether they can see it or not is having the fox guard the chicken coop, and that's just not the right way under the Constitution.
Yeah, no, we saw this happen with Michael Cohen. You know, there was similar legal things. His legal process didn't pan out as much, but I mean, two questions here. One, how much trouble could Giuliani or Trump be, because he's lost the protections of office, obviously. Now, so the first question is, like, could there be potential charges if they find something that bars on the side of criminality or even questionable criminality, where, you know, there may be an exchange of a hypothetical or something like that? Could they pursue that based on this, or is it protected enough where it's total immunity?
The answer is yes and yes. It is protected. There is immunity. But do you know what the head of the KGB, Lavrentiy Beria, said to Stalin?
Show me the man. I'll show you the crime.
The crime. They're looking hard. I don't think they have anything on this registration because Rudy Giuliani was representing an American. He was representing the president. He was doing investigations in the Ukraine to see if it can help his president. That doesn't generally require any kind of registration. But I have to tell you, the idea of a search warrant for a violation of a registration, that makes no sense. That's disproportional. What you do in a situation like that is you have a subpoena, or you produce very compelling evidence, which they couldn't in this case, very compelling evidence that the former United States attorney for the Southern District of New York was going to engage in obstruction of justice by destroying evidence. That's just not going to happen. He volunteered to turn over evidence, not only involving himself, but involving other people. And so this was just a misuse of the search and seizure power. Initially, it was turned down. Now it was approved both by a judge and by the Attorney General of the United States. So it wasn't lawless action, but I believe that they acted inconsistently with both the spirit and the letter of the Constitution, and that there should be remedies for it. Now, the other thing is Donald Trump could enter this case, and other clients of Rudy Giuliani could enter the case, just like if it was my cardiologist who was searched, I could enter the case because the information is my information. The lawyer only had it, but it's my privilege, and they went after privileged information that I gave, that the client gave, the patient gave, the penitent gave. And if they can do that with Rudy Giuliani, they can do it with your priest and your rabbi, your doctor, your psychiatrist. They could do it to a journalist. If you have a confidential communication with a journalist, and then they go and they search warrant the journalist, that information then discloses material that is protected by statute, information given by the journalist. So it's just shouldn't be done this way. It should be done through subpoena. And that is the constitutional route to getting evidence.
Yeah, I mean, and of course, nobody's going to be held accountable for it. So I want to ask you,